Okay, Judge,
All
you
right.
should have the PSI form now.
Yeah, it hasn't come in yet, but I'm sure it will here in a second. All right. Are we ready to call a case, or anyone need to talk about anything?
I am ready.
All right.
Ready, Judge.
Then let's be on the record in case number 2020-CR852, captioned State of Kansas versus Daton Petrey. Would the parties announce their appearances, please?
The court, the state appears by Assistant District Attorney Claire Thibodeau.
May it please court, Daton Petrey appears in person in custody and by counsel Zach Anthony, both via the Zoom platform.
All right. Mr. Petrey, we're going to go over your plea today. Let me ask the parties first. Has there been a prelim or a waiver?
Neither.
Okay. Did you talk to Mr. Anthony about
Yes,
that?
Judge. We understand that we have a right to a preliminary hearing. We would waive it at this time so we could go forward with the plea.
Is that correct, Mr. Petrey?
Yes, sir.
All right. And Ms. Thibodeau, on behalf of the state, you also waive preliminary hearing?
Yes, Your Honor.
All right. I'll find both parties have waived preliminary hearing, bind the defendant over for trial, enter a plea of not guilty on his behalf until we get finished with our plea here. All right. Mr. Petrey, to do this plea, I'm going to have to ask you a bunch of questions. If I ask you something you don't understand, I need you to tell me that so you and I can talk about it until we're sure that we're both talking about the same thing. If at any time during this questioning you want to talk to Mr. Anthony in private, you just tell me that, and I can send you guys to what's called a breakout room where you can talk privately, okay?
Yes, sir.
All right, to get started, I need to have you sworn in. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
All right, go ahead and put your hand down. Mr. Petrey, how far did you go in school?
Graduated. I got a little bit of college done.
All right, you read and write English, okay?
Yes, sir.
I know you're in custody, but as you sit here today, are you under the influence of any alcohol or drugs or prescription medicine that might keep you from understanding what you're doing?
No, sir.
Feel like your mind's clear today?
Yes, sir.
Do you know what you're charged with?
Yes, sir.
You know that you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. You understand that?
Yes, I understand.
Okay.
Yeah. Is that
And-
right, Zach?
Say
Yeah.
that again?
I apologize, sir. I'm Mr. Anthony. Is that what's right?
So remember, I'm sorry, Judge, just briefly,
Okay.
I went over the petition with Mr. Petrey this morning in its entirety in person in the jail. And we read through all the rights you've enumerated. So I mean, I admit he's probably had a lot thrown at him, but we definitely understand that we have a right to a trial and that we're giving up that right.
Yes,
Right.
sir. I apologize, sir. I
That's
understand.
quite all right. I just want to make sure that you understand what you're doing, okay? That's the point of all this whole questioning.
Thank you, Your Honor.
You bet. So if you wanted to maintain your not guilty plea, like I said, you would have a right to a jury trial. And at the trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You wouldn't have to prove anything yourself. Do you understand that?
Yes, sir.
Mr. Anthony would help you throughout that trial. He would cross-examine and confront all of the state's witnesses. He would call any witnesses that you wanted called. He could call you to testify if you decided to testify, but you would also have a right not to testify, which means if you went to trial and you decided not to take the stand, the state couldn't use that against you. In other words, they couldn't get up and argue, well, he must be guilty because he didn't tell you his side. Do you understand all those parts of a trial?
Yes, sir.
All right. So if we did that whole trial and at the end you were convicted, you would have a right to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. Do you understand that?
Yes, sir.
All right. So if we go forward with this plea today, you're going to be giving up all those rights. There's not going to be a trial of any kind in this case. You understand that?
Yes, Your Honor.
All right. Mr. Anthony's been your attorney throughout the case. Are you satisfied with his advice and counsel?
Yes, sir.
All right. I'm going to share the screen that I have here with what Mr. Anthony sent me as the plea petition. He tells me that he went up there this morning and went over this whole document with you. I'm just going to kind of scroll through it so you can see it. Did Mr. Anthony go over this whole plea petition with you?
Yes, sir, he did.
You feel like you understand everything that was in it?
Yes, sir.
All right. Now it says here that the agreement is that you're going to plead guilty to the amended count 1, which charges you with an aggravated battery, a severity level 7 person felony, and that the parties are going to agree to recommend to the court to give you the aggravated term in the appropriate box and grant you probation. Is that your understanding of the entire plea agreement?
Yes, sir.
Has anybody promised you anything else to get you to plead guilty today?
No, sir, they have not.
Anybody placed any force or threats against you to make you plead guilty today?
No, sir, Your Honor.
All right. So I see in here that it talks about the recommendation that the parties are going to recommend to the court, that being the aggravated term in the box and probation. You understand that while I listen closely to everybody's recommendations, that I'm not party to any agreement and I'm not bound by the recommendations. I could give you any sentence that the law allows me to give you. Do you understand that?
Yes, sir.
Okay. Mr. Anthony, what do you believe your client's criminal history score is going to be?
Judge, I think parties believe that he's likely to be a C. He has some, I think his entire criminal history, I believe, is from out of state. So clarification's a little bit confusing on that. But I think Claire sent me an email saying she thinks he's a C. I've talked to him about it. I think he's a C. I think that's where he's going to fall.
All right. So, Mr. Petrey, I'm sure that your lawyer has shown you that sentencing grid and talked about where your criminal history is and what kind of sentence you could expect in this case. Is that correct?
Yes, sir, he has.
Okay. So I expect that he does a very good job, and I expect that they're right about your criminal history. But I have to, for purposes of today's hearing, since I don't know what your criminal history is going to be, for purposes of today's hearing, I have to assume you have the very worst criminal history possible so that I can advise you of the maximum sentence that anybody can get for this crime. Do you understand that?
Yes, sir.
Okay, you sound a little hesitant. I want to make sure that you understand. I'm not saying that you have the worst criminal history. I'm just saying that until it's official, I just have to assume that you do so that I can tell you the maximum that anyone can get. Is that clear?
Yes, sir.
Okay, good. So as I've scrolled up to here, you see that the maximum that anybody could get for this crime is 34 months in prison and a fine of $100,000. That would also include 12 months of post-release supervision. Do you understand those are the maximums?
Yes, sir.
All right.
Judge,
Yes.
if I may, I apologize. I was going off of an old plea petition. That statute number is not correct. The information is correct, but I failed to correct the statute number for the amended information.
Okay. And I think the statute number, if I still have that up, just for complete clarification here, let's see. I don't know if you can see that. It's 215413 B1B.
And Judge, I had that information correct when I reviewed it with him, but I did not change it in the petition. So
Sure.
he is aware of the aggravated battery that he's pleading to. We certainly talked about that, and the information all listed there is correct. I just didn't change the actual written part of that petition.
Excellent. All right. Mr. Petrey, do you have any questions for either me or Mr. Anthony at this time about anything we've gone over or anything in that plea petition?
No, sir. I feel as though I understand what's going on pretty well.
All right. Noting everything that we've talked about, do you still intend to plead guilty to the amended charge?
Yes, sir.
All right. Mr. Anthony, do you know any legal reason why your client should not plead guilty?
No, Judge.
All right. Then I'm going to ask you to the amended charge, charging you with aggravated battery, a severity level 7 person felony. How do you plead, guilty or not guilty?
Guilty, sir.
All right. I'm going to ask the state now to tell me what they think the evidence at trial would be. I want you to listen closely because when they're done, I'm going to ask you if that's what happened. Okay.
Judge, on December 18th of 2020, officers from the Edwardsville Police Department responded to 549 Beach Street in Edwardsville, Wyandotte County, Kansas. When they were there, they spoke to John Edward Curtis Jr. Mr. Curtis let them know that he was punched in the face by the defendant, Daton Petrey. He had an approximate 2-inch star-shaped cut above his right eye that did require stitches. Later, the police spoke to Mr. Petrey, and he said that he did punch Mr. Curtis with his right closed fist on Mr. Curtis's face.
All right. Mr. Petrey, is that what happened?
Yes, sir.
All right, thank you. I will find that the defendant has freely, voluntarily, and intelligently entered into this plea. He knows the nature of the charges and the consequences of the plea. The state has provided a sufficient factual basis for a finding of guilt, and the defendant has acknowledged that factual basis. Therefore, I will find he is in fact guilty of the amended charge of aggravated battery, a severity level 7 person felony. I'm going to order a pre-sentence investigation be conducted and continue sentencing pending receipt of that. Parties, I'm looking at April 2nd, that's a Friday. I have a 10 o'clock available. How does that work for you, Mr. Anthony?
Judge, I can do 10 o'clock.
Ms. Thibodeau?
That works for me, Your Honor.
Okay, that's when I'm going to set sentencing. We'll consider it for Zoom. Mr. Anthony, what's the status of your client's bond at this
Right,
time?
Judge. We would like to be heard on bond, obviously. At this point, we would ask, I think the parties believe that he's presumptive probation. While the state didn't spend a ton of time on the facts in this case, it was a very brief fist fight between a girlfriend's father and my client. I honestly would characterize this as closer to a misdemeanor than a felony, although this is over now. I don't think he's a danger to the community. I don't think he's a danger to flight. I don't think he's any of those things. And he acknowledged that what he did was wrong, and he'd like to put this behind him and show you that he can do probation. So with all that being said, we would ask that the court entertain an OR bond at this time.
Ms. Thibodeau?
Judge, I would just ask that the defendant have no contact with the victims or witnesses, and for the court to let him know that if he fails to appear for sentencing or commits a new crime, we're not bound by our plea offer.
Yes, Mr. Anthony.
Very briefly, Judge, we have no problem with the no contact with the victim in this thing, but as I mentioned earlier, I think one of the witnesses, although it wasn't really ever an actual witness, is the girlfriend we're talking about. And it's my understanding she wants to have contact with him. He wants to have contact with her, that this wasn't the end of their relationship. So as long as, and I could say her name here, Lacey Joe, as long as Lacey Joe is not included in that no contact order, we have no problem with the rest of it.
Ms. Thibodeau?
That's fine, Your Honor.
All right. So I'll order no contact with the victim in this case as a condition of bond, and then I'm going to OR bond. All right. So Mr. Petrey, here's the deal. I'm going to let you out today prior to sentencing, okay? I've set your sentencing for April 2nd at 10 a.m. You need to keep in touch with Mr. Anthony between now and then so he knows where you are, and I'm going to send him an invitation to our Zoom hearing for sentencing. He's either going to share that with you so that you can join us or have you into his office so that you can do it from there. But he needs to keep in touch with you, because if for some reason you didn't show up at that next hearing, the state they're not going to be bound by their plea agreement, and they might ask for some jail time or some other sanction for you not showing up, okay?
Yes.
Do you know how to how to contact Mr. Anthony once you're out?
Yes, sir.
Okay, yes, go ahead.
I apologize for interrupting you, sir. So when I get out today, what do? I need to go to the building up the street and go?
No, here's the deal. Your attorney has sent me what's called a PSI request. It has all your contact information. Probation is going to reach out to you probably within the next week or two to set up an appointment to do an interview for your pre-sentence investigation, okay? That's another reason why it's important to keep in touch with Mr. Anthony. Let's say 2 weeks go by and you haven't heard from probation. That means something went wrong. And you need to let Mr. Anthony know that so that he can coordinate with probation to make sure you get that done. Okay?
Yes, sir. I'll make sure I call him at least once a week or whatever I got to do, man. Yes, sir.
All right.
Sorry, sir.
So again, that's between you and Mr. Anthony. Like I said, you should hear from probation in the next 2 weeks. If you don't, you definitely need to reach out to Mr. Anthony to let him know that, okay?
No problem, Your Honor.
All right. OR bond is approved. No contact with the victim. Sentencing set April 2nd at 10 a.m. Mr. Petrey, one last thing I have to advise you, as a convicted felon, it's prohibited for you to own or possess a firearm. Certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons, okay?
Yes, sir.
All right. Anything else for our record today?
Nothing from us, Judge.
We are adjourned. Thank